my presentation, Copyright and Generative AI, Demystifying AI-related Copyright Issues, makes the start today because copyrights have always been around and they are certainly important when it comes to, well, legally assessing the use, the development of artificial intelligence, of generative artificial intelligence in business. And to give you a little bit of a preview what we cover today, the copyright implications, namely possible infringement of copyrights. Is there really a risk about that? Further copyright implications, how is the output protected? How can the output be protected? Ideas for use of generative AI that avoids copyright issues. And of course, I will cover a few other IP implications, but not too many. The focus today is certainly on copyrights, which does not mean that other intellectual property rights are not somehow impacted by the use or cannot be somehow impacted by the use of artificial intelligence, such as trade secrets or patents. And what we will cover a bit later today, so that is not for me, the regulatory implications, in particular the AI Act, and of course, privacy implications. Is there really a conflict between AI and copyrights? And in order to elaborate a little bit on that topic, just as a very brief reminder, what is generative AI? What is it doing, actually? And first, when we have a look at generative AI and when we see how the normal user is perceiving AI, it appears to be something that can perform tasks that normally require human intelligence, learning, reasoning, generating outputs. But what really happens when we talk about using generative AI, large language models like, for example, ChatGPT, or when it comes to images, diffusion image generation models like Neuroflash, they use statistics to estimate the best word or pixel to follow the previous one. And by this, they try to match the style and the content of the context. And if you want to equate it to, well, already known technology, it may be best equated to a sophisticated autocomplete function. When it comes to the use of AI, there is, of course, a plethora of use cases. And just for playing a little bit around and to illustrate the chances and maybe some of the risks, I told ChatGPT, please create a new marketing campaign and a slogan for a new painkiller. So we are now in the area of the pharmaceutical industry. I also told it, please consider limitations for drug names and potential trademarks. And of course, to prompt a little bit more detail, be creative and modern, create a fancy brand and a cool slogan. And that was the task ChatGPT had to complete. I'm not going to read this all out aloud, but I really got something. We can all consider whether that is really cool, but nonetheless, here is something. I received a brand name, namely Relief Excel. I got a campaign name, Unlock Your Pain-Free Potential with Relief Excel, and a slogan, Break Free from Pain, Live a Life Unlashed with Relief Excel, and a complete campaign description with a few more slogans and marketing messages that I'm maybe free to use. We will come to that a little bit later. But of course, there is no real marketing campaign without good pictures, without a good packaging. And so I also asked Neuroflash to create a modern, cool packaging for the new painkiller Relief Excel, and it must be so creative that one must be able to claim copyright protection under German law for it. And I also gave it a little bit more information, use graphics that symbolize the way it works. It's a tryptane agent, always being polite when prompting. I said thanks, and Neuroflash provided me with this lovely packaging with some fancy drawings on it. Of course, you can bring then the brand to it. And so in a couple of minutes, I had a complete marketing campaign, I had packaging. So, well, that can save me really quite a lot of time. Or whether that is really the case, again, we'll come to that later. So having said all that, it works out quite nicely. And now we have to go a little bit into details of law. And well, of course, the first question when we talk about a potential conflict of AI and copyright, I save you, we do not want to use too many or do not state too many sections from the German Copyright Act. What is a copyright? And the section 1 of the German Copyright Act tells us that authors of literary, scientific, and artistic works shall enjoy protection for their works in accordance with this act, namely the Copyright Act. And that is not already very helpful, but section 2, subsection 2 helps us a little bit more. And there it is said that works within the meaning of this act are only personal intellectual creations. So what could that be? And lucky us, there are, of course, definitions what this really means. And when it comes to personal, we all know, or most of us know, that a certain work must be created by a human being. Then it must be intellectual. It must contain verbal or non-verbal message or information. Merely handcrafted products are normally not works. And it must be a creation, so there must be subjective novelty of the work. And when it comes to assessing all these criteria, when you put a case in front of a judge and asks him, well, does this really enjoy copyright protection? Then the judge will use criteria like individuality, level of design, originality, and very, very important, statistical uniqueness. How likely is it that somebody really creates a work like that? And when we have a look at that, we will compare that at a later stage with what generative AI is actually doing. We already gave a brief definition of what AI, generative AI is and what it is doing. So when we have a look at this artificial intelligence, there are basically 3 stages we must have a look at. That is the training, the input, and the output. As I mentioned prior, LLMs are trained on large data sets that can include copyrighted books, images, or other media. But now there comes the question. To use that would mean duplicating it. That is already something or an activity that must be permitted by a copyright owner in general. And here the first question comes up when it comes to AI. Where does this data come from? Does consent exist? Are there any exceptions to the copyright protection that would allow programmers of large language models to use copyrighted texts or works? This is certainly the first question. Then, of course, what is happening within AI? Of course, AI, generative AI, is generating something. And here the question comes up, knowing that the models are trained with huge amounts of data, can AI models commit copyright infringements by duplicating texts that they have been trained with? And finally, we are the users. But of course, when we use AI, we must also be careful, because if we, for example, take a text and tell the LLM, please rephrase the following texts, we may have already committed a copyright infringement, because the text that we give or enter into the prompt may also be copyright protected. And we have duplicated it by copying, pasting it into the large language model. Now, the law is not in any respect as strict as it appears. One may think from what I just said, wow, AI is a potentially dangerous technology, but that is not always the case. As I just mentioned, of course, there are exceptions or limitations to copyright protection. And what is in particular important is the exception in view of AI. And that is implemented throughout Europe. And one very important example for this, text and data mining, a technique that involves the automated analysis and extraction of information from large amounts of data, texts, images, or audio sections for various purposes, such as research, innovation, or journalism. So the lawgiver did not mean to protect copyright at any cost, but they also wanted the openness to new technology. And text and data mining can certainly pose a good exception for training AI models. There are certain limitations that one must clearly see, but nonetheless. We just touched upon the 3 criteria of the copyright protection. And I think it is quite interesting for you all, and maybe you've already done that, how perceive large language models themselves. And I've taken here the part from ChatGPT's, Microsoft's Copilot general terms and conditions. And they are a little bit self-critical. They say Microsoft doesn't claim ownership of the output of the service. And they say this is because generative AI systems may produce similar responses to similar prompts or queries from multiple customers. But maybe they've also understood something else, namely that, well, maybe a human being is not sufficiently involved here. And that, you remember that, is a prerequisite. It must be a human creation. And can we really talk about human creation when we do something with the assistance of an LLM? And also quite interesting, they say, if a third party sues a commercial customer for copyright infringement for using Microsoft Copilot, we'll defend the customer and pay the amount of any adverse adjustment, etc., etc., etc. So, but what is, I think, quite noteworthy, even if you feel more comfortable, and maybe you can really do that, the lawyer would always say that's all quite nice, that they will help you, but of course, then it comes to questions of documentation, of use and prompts, the burden of proof, and strict liability claims, where this promise of help may have a limited effect. And of course, from all this, we can draw certain conclusions. And I think one very important conclusion is, if we have doubts, and I think there should be doubts, when we use large language models, whether that output is actually copyright protected, the law already, without having known at that point in time about what artificial intelligence is, may give us or indicate a way forward. And we have a judgment from the German Federal Court of Justice, and there in this judgment, the Paler theory is laid out. And that does mean, what are the criteria to define whether there is a new creation that is independently protected when somebody uses an older work? And the court told us in this decision that if you compare the earlier work and the new work, and if the overall impressions of the two differ, it is unlikely that there is a pre-production or an adaptation, but possibly a free use. And a free use means a newly created copyright-protected work. And I think this, again, is not judgment that exactly deals with AI, but it gives us clearly an indication what we have to do or what can be done in order to protect output of artificial intelligence. And this leads us to our conclusion when using AI, when creating AI, coding AI. The key points certainly are the training and the input. Is it done manually? TDM, text and data mining, may be a way forward when doing it manually. Do you have all the licenses? And again, think of all intellectual property rights. Even if something is not protected by copyright, it may be protected as a trade secret. So it may not always for free, or it cannot always be freely used. And maybe even more important, the output. Can the output be infringing? We just discussed a little bit about how generative AI is working. And the more data has been used to train it, I think the more unlikely it is that there will be a direct copyright infringement. There may be exceptions, but generative AI is trying, to create something new and not to use what it has already seen. Another question, of course, is the ownership. And here it comes to very important questions, in particular in view of the prompting. There is something one may call the typewriter test. Maybe there is a way forward. The more detailed you prompt something, the more you make the large language model to a typewriter, the more you dictate what it shall write, the more likely it is that the output can be copyright protected because it is the result of your intellectual activity. And even if you don't do that, maybe you can apply changes to those. The Paler theory, the judgment I just told you about, if you change it to a degree that it is certainly, or the overall impression is changed to a degree that it would be seen as your own creation, then you may also be on the safe side in view of the copyright protection. So these are also suggestions how you can potentially mitigate risks when it comes to using AI. And that's my part. And thank you for your attention.
Thank you very much. I think that provides a very clear orientation which legal fields relate to potentially to AI implementations. And we will continue now with Carsten's insights and yes, sort of summary of the AI Act.
Yeah. Thank you for the introduction. I have the great pleasure of telling you a bit about the brand new AI Act, which just came into force on August the 1st, 2024, and which is in fact the world's first comprehensive AI law. And with this act, the EU wanted to create a Europe-wide legal framework for the development and use of artificial intelligence, whereby it is intended to regulate AI systems according to the risk they pose, which imposes different requirements on different market participants. So what is the purpose of the Act? In general, the Act aims to enhance the internal market by establishing a unified legal framework for AI systems in the Union. It aims to promote human-centric, trustworthy AI, while to ensure health, safety, and fundamental rights protection, including democracy or even environmental protection. The Act shall also safeguard against harmful AI effects and supports innovation, and shall prevent member states from imposing restrictions unless explicitly allowed. As part of the European digital strategy, this is the first harmonizing legal framework for AI in the European Union, and similar to the GDPR, it applies directly in the member states. The AI Act contains a very long list of definitions in Article 3, 68 in total. These definitions, of course, are all important, but a detailed discussion would go beyond the scope of this presentation today. So therefore, I want to focus on a few crucial ones. First of all, and this is actually the linchpin of the AI Act, the AI system. I don't want to read the definition out loud, but in summary, an AI system means a machine-based system that is designed to operate with varying degrees of autonomy and can demonstrate adaptability once deployed, and that infers for explicit or implicit goals from the inputs it receives, how it can produce outcomes such as predictions, content, recommendations, or decisions that can affect physical or virtual environments. Please note that the term system itself is not defined in the Act, but it probably means hardware and associated software. In addition to the AI system, I would like to further focus on two other terms whose difference is crucial for the application of the AI Act: provider and deployer. Provider within the meaning of the AI Act is in particular a natural or legal person that develops or has developed an AI system or an AI model with a general purpose and places it on the market under its own name or trademark. In this context, it must be noted that the term AI model is also not defined in the Act, but one could describe it as a mathematically representation integrated into software, including perhaps an interface, user interface, and hardware to form together an AI system. So the decisive factor here is that the provider develops an AI system or an AI model itself or has it developed in order to then market it in its own name. On the other hand, a deployer is in particular a natural or legal person that uses an AI system under its own responsibility, unless the AI system is used in the course of a personal or a non-professional way. And for a deployer, it is not necessary to develop an AI system or AI model itself. Instead, the AI system is used professionally under one's own responsibility. And as already mentioned, the difference between provider and deployer is decisive for the persons concerned, because depending on whether they are providers or deployers, different provisions of the AI Act apply to them. Since the AI Act takes a risk-based approach, the actual heart of the AI Act is the categorization of the risk classes. The higher the risk to society or an individual posed by an AI system, the more far-reaching the more the requirements in the AI Act actually are. So the AI Act categorizes AI systems into 4 risk classes: unacceptable risk, that is mostly prohibited; high risk, that is strictly regulated; limited risk, mostly transparency requirements; and minimal risk, that is largely unregulated. And this classification has far-reaching implications for the development, for the use, and monitoring of AI systems. And while users of AI systems do not have to fulfill any obligations, providers and deployers of such systems in particular are subject to many obligations. So in the following, I would like to briefly go into a few of the systems in more detail. And most provisions of the AI Act concern AI systems that pose a high risk to health, safety, and fundamental rights of natural persons. And therefore, high-risk AI systems must be registered in an EU database and undergo a conformity assessment procedure. The providers must set up a risk and quality management system, create technical documentation, or must implement cybersecurity. The AI Act also includes so-called general purpose AI models. These models, such as the language model ChatGPT, are trained with a large amount of data and can be used for various tasks, which poses particular risks to the rights and freedoms of EU citizens. And to mitigate these risks, providers of such general purpose AI models must comply with specific transparency and notification obligations. So what are the transparency obligations for AI systems? Providers and deployers of AI systems must generally fulfill transparency obligations regardless of the risk. Users must always be able to recognize that they are interacting with an AI systems. Results generated by AI must be labeled accordingly, for example, with a watermark. If synthetic sound, image, or video recordings are generated with the AI, so-called deepfakes, this must also be disclosed. And now the main question is, who must fulfill the obligations? The AI Act affects a number of parties. Most extensive applications apply to providers and deployers, but in some cases also to product manufacturers, authorized representatives, importers and distributors of AI systems. And it is important to note that a change in the intended purpose of your AI system, for example, can lead to an AI system that was originally low risk becoming high risk. And companies then become providers of high-risk AI systems and then must also fulfill the obligations applicable to such providers. Companies or parties are therefore well advised to define the purposes of their AI system within the company in advance in order to avoid the far-reaching applications of providers of high-risk AI systems, or at least to have enough time to prepare for complying with them. When must the obligations be implemented? So as the AI Act is so comprehensive, the companies, persons affected have quite a long time to adapt to the respective requirements. The AI Act will apply in its entirety from August 2nd, 2026, although some provisions will apply earlier or even later. The general provisions, for example, on AI competence and on prohibited AI systems will apply from February 2nd, 2025. The provisions on notifying authorities and bodies general purpose AI models, governance and sanctions will apply from August 2nd, 2025. The provisions on the classification of high-risk AI systems and the associated extensive obligations will only apply from August 2nd, 2027. And one last point, what are the fines for violation? And this is also interesting, the fines for violations. If not implemented correctly, there's a risk of hefty fines. Depending on the type of infringement, penalties of up to 35 million euros or 7% of the annual global turnover may be imposed, whichever is higher. So that was my short presentation in which I wanted to very briefly address some key points of the AI Act. The AI Act itself is very comprehensive, and of course, with regard to the time, I could not tackle every detail, but thank you very much for your attention.
Thanks a lot. That was, I think, a good overview of what we can expect from the AI Act. And now let's have together a closer look how an AI software vendor, like how Kauz-ai, has adapted the existing legal framework, maybe also which new questions need to be tackled along the way.
Thomas Rüdel from Kauz. What you see here is our main product, the Kauz-ai Studio, which is a platform, no-code platform you can use to build AI systems. And of course, for us, the questions just raised are extremely important because we need to understand what we have to do as providers, deployers, whatever the right term is, of AI systems, and perhaps even more importantly, what our customers have to do. Because we are giving, of course, these products our customers, or we enable our customers to build AI products. And this is the perspective I'm going to take. Yeah. So what does it mean for, I'm not a legal expert, but what does it mean for a provider of an AI platform or for a customer or a partner using such a platform? Just very briefly, introducing Kauz, because you may not know us. We are in Düsseldorf, founded in 2016. We are about 30 people. We have about 180 customer operating chatbots live. Some of our customers you see here: savings bank, cooperative bank, insurance companies, IT companies, retailers, and so on. But only so much about ourselves. I will now expand a little bit and try to argue what it means in practice, what we have just heard. First about the AI Act, and then I will also speak a little bit about data privacy issues, because I know they are also very, very important on the minds of customers when talking about AI. I will just pick up here on what Carsten Goldstein told us about the risk classification of AI systems. I think largely this is good news, actually, because what it says that while there are prohibited systems and there are high-risk AI systems, for example, in critical infrastructure or medical applications or making very critical, say, hiring decisions, There are also many low-risk AI systems. Systems often, like chatbots, that involve direct interaction with people, but yeah, in low-risk environments like customer advice or knowledge management, or actually the areas where most of our chatbots operate. And while there are obligations in these areas as well, they are largely transparency obligations. There's no prohibitive regulation or similar. So I think this is good news. As long as you can make sure that you're running a low-risk AI system, you have to observe the transparency obligations, but then you're in good shape, casually speaking. Let's look also at the distinction between providers, deployers, and other roles here in this framework. There's actually a possibly quite complicated setup. You have a provider like OpenAI, who builds these models, and then you have a downstream provider like us, who uses these models, and it's often then called a deployer, and then you have a customer. From the perspective of the AI Act, the customer can also be considered a deployer. The distinction is really not very clear here, and it can be even more complicated. You can have a provider, you can have a deployer like us, and then you can have one of our partners, for example, an IT company that uses our platform and then provides chatbots to their customers. In some sense, all of these players are deployers or downstream providers. But that distinction is very important, and that is what Carsten also said. Yeah, because the obligations for the original providers like OpenAI and for the downstream players like us and our customers are very different. The original providers, they have to provide detailed technical documentation to the authorities. They have to give us essentially sufficient information that we understand what we're using there and can tell our customers what they are using. But it's their obligation to provide us with this information. They have a strategy for compliance. They have to have a strategy for compliance with the copyright law that Konstantin Reak has elaborated on. And this can be quite challenging, of course. But again, it's their obligation primarily. And they have to provide a sufficiently detailed summary of training data. Now, as operators or downstream providers like us or our customers, what we have to do is we have to provide general description of the AI models. So how many parameters does it use? What modalities? So text or voice or video or what other modalities it uses. What the license is, what type of data are used in training, but not specifically what data. So I think all of this is very, very acceptable and possible to do. And in fact, we do it already today. And in addition, I think that is very important for the user. Also, we have to label what is AI-generated content and make it transparent to the user. So the user can always be clear, is he dealing with AI-generated content or not? Actually, these transparency requirements that apply to us and our customers as well, they are spelled out very explicitly in Annex 12. I will not go through it here, but in principle, it's what I said on the previous slide, and in principle, it's very tractable, really. And let me show in particular what this labeling means, and we have so that it is recognizable as artificially generated content, and we have already implemented that. What you see here is our Kauz bot on our own page, asking him, can you explain in 2 sentences how you handle data protection? And then he gives an answer how Kauz handles data protection. Quite a good answer, I think. But as you see below there, it states that it is AI generated. And in the introduction, it says that all AI generated statements will be labeled as such. So customers know this is not something that has explicitly in this way been written by a person. This is AI generated content. And this is the obligation, and that is already fulfilled today. As you can see here, and I will pick up on that now, but let me summarize this first. The whole, you have to make sure, absolutely, is your application high risk or not? Yeah, and there are very clear criteria if it's high risk or not, and I think it's not too difficult to decide. Of course, from a legal perspective, it can be more difficult in some cases, but I think it's very clear. Many, and actually most or nearly all of our applications, probably all, are not high risk, they are low risk. And then we have these transparency obligations, and that's it, and I think we can deal with it, and that brings clarity. If it's high risk, it becomes a lot more complicated, but that would be a separate discussion. Now, finally, let's spend 1 or 2 minutes on the other point that is mentioned here. How do we handle data protection in the field of AI? And this is now just one slide, so this is the last one of the presentation at the same time. This is largely handled through the choice of hosting. Where do you run your systems, actually? And there we offer 2 models, and we call them secure and very secure. Secure is using a public model in the cloud at Azure OpenAI service, where we keep the own instance of the chatbot platform, and ChatGPT or other models by now can be accessed on European servers. And this approach guarantees you 2 things. It guarantees you that your data are not used for training, and it's only European servers that are used, and the data do not leave Europe, so to speak. In particular, they are not run on US servers. And that is for many or most purposes a secure environment. Of course, ultimately, every company has to decide for themselves if that is the level of security that is sufficient for them. But there are even more secure options, and some of them are listed here on the right-hand side. Depending on your preferences, you can run a model on a, let's say, a managed server in a German data center. You can even run it on premise, provided you have the hardware and are willing to spend the money for it. And now there's even a further possibility. You can use a so-called confidential computing environment, which is something that we offer in cooperation with Edgeless Systems. This is an approach where data in operation are kept encrypted. So they are not just sent encrypted, but they are processed in an encrypted way, which is the maximum security, I think, that you can achieve. So this concludes what I want to say. I hope it was a little bit useful to demystify some of the issues surrounding AI regulations from a kind of recipient perspective.